Welcome to the third part of our Introduction to International Criminal Law, where we consider in some detail the crime of genocide. So I'm going to go through the elements of the crime, the ways in which it can be committed, and the key legal controversies. So we start with the Genocide Convention itself, and it really defines the crime simply in Articles 1 and 2 of the Convention. Article 1 states, "The contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and punish." So Article 1 affirms the existence of the crime. Article 2 defines it and says, "In the present convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial or religious group as such." Then it lists the offences that can constitute genocide as killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, and finally, forcibly transferring children of the group to another group. So you'll have noted the fairly heavy use of the word group in that definition. So our first question is the nature of the groups protected by the Genocide Convention. And we see at the beginning of Article 2 reference to a national, ethnical, so as we would now say ethnic, racial or religious group. The first question then is that a closed list? Because if so, it excludes political and economic groups, or groups based, for example, on sexual orientation. Now, the reason that might be controversial is we frequently refer to the idea that a genocide was committed in Cambodia during the rule of the Khmer Rouge. However, the majority of people killed by the Khmer Rouge were subjected to conditions of life that inevitably resulted in their death, not because they were religious or belonged to a particular ethnic group, and indeed they belonged to the same national and ethnic group really as their persecutors. They were the subjects of international crimes because of their educational status, their political affiliation, or because they were perceived as bourgeois. These were effectively crimes committed in a warped communist ideology that regarded those with university education or those of a certain socioeconomic status as a threat to the social order who had to be excluded and preferably destroyed. Only a minority of those killed by the Khmer Rouge were killed because they were religious. So there is some controversy about whether that list of protected groups is sufficiently wide. Some have attempted to interpret it as really meaning any stable and permanent group should be protected, and that approach was taken by the Rwanda Tribunal Trial Chamber in the Akayesu case, and in a number of international reports and scholarship. However, that has generally not been the approach of the tribunals. The list is treated as exhaustive. Alright, then if we look at these terms national, ethnic, racial, or religious groups, how do we define them? These are actually groups that resist objective definition. Despite the assumptions of the 1930s and 1940s, it's very difficult to identify someone's ethnic group simply by their physical features, for example. And there may be debates even within a religious group as to who truly belongs to it or not. And these categories, national, racial, ethnic and religious, may obviously overlap. This has led to a number of difficulties, but the first can be resolved to some extent by what's called, in the Kirstich case, the single phenomenon approach, or by William Shabbos, one of the major contemporary scholars on genocide law, as the four corners approach. That is, these four terms aren't really different things. They correspond to the same idea, and that idea is what would have been called, in the period after either the First or Second World War, a national minority. So a minority group with a distinct identity that exists within a state, and that has elements at least of this national, ethnic, racial or religious distinct identity. Now, even if we accept that, there's still a sort of problem about how do we account for the subjective construction of these groups. So the idea of an ethnic group is something that might involve both internal subjective identification, we as members of the group believe we are a group, but more commonly in the case of genocide, an external subjective view, that is, a view on the part of the persecuting group that people belong to these groups. So how is that to be taken into account? Well, the case law in general emphasises that the construction of a protected group is a question of local historical, political, social and cultural context, and it's really only in that context you can assess what is the relevant group and who is a part of it. And there's a long line of cases from the Tribunal for Rwanda discussed in the chapter on genocide in the book by Robert Cryer and his co-authors, An Introduction to International Criminal Law and Procedure, which is listed in the additional reading. In any event, these cases from the Rwanda Tribunal involve a mixed approach. So they're based on subjective identification, the views of perpetrating groups and to some extent the victim groups, but they also take into account what we might think of as objective contextual factors. So for example, in Rwanda, where the genocide was principally a crime in which members of the Hutu ethnic group killed members of the Tutsi ethnic group, in that context, the government prior to the genocide started issuing identity documents which listed people as either Hutu or Tutsi, thus codifying subjective perceptions about who belonged to which group. Because, of course, over many generations, these groups have intermarried to a considerable extent. They don't necessarily have different religions or dialects, and actually, superficially, it's rather difficult to tell whether someone might be a Hutu or a Tutsi. So that's the first question. What are the protected groups and how do we identify someone as falling within them? The second question is what constitutes the prohibited acts that can form part of genocide? The first means of committing genocide is obviously killing members of the group, and this is interpreted as meaning voluntarily or intentionally causing death, which is a fairly straightforward, well understood definition of murder. Beyond killing, genocide can also be committed through causing serious bodily or mental harm to members of the group. This simply makes the point that genocide can be carried out by acts other than killing. And examples in falling within this category from the modern case law, including the Eichmann trial in Jerusalem in the 1960s, the Akayesu case before the Rwanda Tribunal, the Krstić case before the Yugoslav Tribunal, include bodily or mental torture, acts of sexual violence and rape, and deportation, all as being means that could be used to inflict serious bodily harm on members of the group. Another form of committing genocide that has received extensive attention in the case law is that form known as deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. So this is given more substance by a number of quotes from the cases. The Akayesu case from the Rwanda Tribunal states that the means of deliberate inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part include, inter alia, subjecting a group of people to a subsistence diet, systematic expulsion from homes, and the reduction of essential medical services below the minimum requirements. So these are conditions of exposure, starvation, medical neglect that could obviously over time lead to the physical destruction of members of a group. Further, we see in the Kayashema case from the Rwanda Tribunal that the infliction of such conditions may also occur through the deliberate deprivation of resources indispensable for survival, such as food or medical services. And finally, from the Brodinin case at the Yugoslav Tribunal, we have the proposition that also included is the creation of circumstances that would lead to a slow death, such as lack of proper housing, clothing and hygiene, or excessive work and physical exertion. These ideas are further supported by the ICC Elements of Crimes, the document setting out guidance for the International Criminal Court on how to interpret its own statute. These note that the term conditions of life may include, but is not necessarily restricted to, deliberate deprivation of resources indispensable for survival, such as food or medical services, or systematic expulsion from homes. So the ICC elements there appear to gather up some of the Rwanda and Yugoslav Tribunal case law, thus indicating that there's a high degree of consensus that these are some of the manners in which genocide may be committed. Also notably, we have the form of committing genocide imposing measures intended to prevent births within the group. And here the Rwanda Tribunal made a significant contribution to the case law through the Akiyesu case in its trial chamber, which held that first measures intended to prevent births within the group include sexual mutilation, the practice of sterilization, forced birth control, separation of the sexes, and prohibition of marriages. And second, and perhaps more importantly for the development of international criminal law, the trial chamber held that rape may be used as a means of preventing birth within the group, either through the physical forced impregnation of a woman belonging to that group by a man from another group, particularly in cases where group membership is by paternal descent, or B, where the trauma inflicted by rape results in the victim subsequently being unwilling to procreate, and both have been unfortunately common practices in major conflicts in the late 20th century. Finally, we have the category of forcibly transferring children of the group to another group, and this category has received little judicial consideration, though both in Australia and Canada there have been commissions of inquiry into the practice of removing children from indigenous groups and placing them deliberately with families of European descent. However, in those cases, the question arises as to whether this was done with the intent to destroy the original group. For example, in Australia at the time of these practices, there appeared to be an official and sincere, if mistaken and racist, belief that the indigenous population was doomed to die out in any event, and the only way to save any members of it was to transfer them, as it were, into the dominant culture. So an argument could be made that these policies were not per se genocidal, they were actually done with the intention of making the group's inevitable extinction a gentler, kinder process. Of course, that is not how the so-called stolen generations of children in both Australia and Canada perceive what happened to them. And indeed many activists from those communities still consider that they were rightly described as the victims of an attempted official genocide, albeit one which fortunately did not succeed. We turn now to the difficult question of whether genocide requires a contextual element in much the same manner as a crime against humanity or war crime. So as a question of common sense, we could ask whether genocide requires an organised and or widespread pattern of acts orchestrated in accordance with a governmental or organisational policy. That is, it would seem to be very difficult to carry out a genocide that was in any way comparable to the Holocaust committed against the Jewish populations of Europe by Nazi Germany without massive organisation and the involvement of a government at the very least, if not an organisation with government-like powers and resources. However, as lawyers, one of the first things we will note is that there is no such express requirement contained within the Genocide Convention. It simply refers to this question of the special intent required. So this leads to the question of whether such a requirement exists within customary law or whether a single person could be guilty of genocide, the so-called lone genocidaire question that was posed in some of the cases before the Tribunal for Rwanda. The International Criminal Tribunal for Yugoslavia Appeals Chamber, in the Jelasic case, put it the following way: the existence of a plan or policy is not a legal ingredient of the crime. However, in the context of proving specific intent, the existence of a plan or policy may become an important factor in most cases. So you'll recall the idea that genocide is a crime of specific intent, that it has to be committed with a particular type of mental state, a question we'll come back to. And the Genocide case essentially says you don't need to have a plan or policy as an ingredient of the crime, but it may assist in proving that particular mental state that is required, the intent to destroy a protected group in whole or in part as such. Now that might not be a completely ridiculous proposition. We can ask ourselves whether it's inconceivable in the age of weapons of mass destruction that an individual might attempt to destroy a group in part through a devastating attack on a particular population centre. So we have these two, as it were, extreme positions. Common sense requires that there must be some kind of organisational plan or policy, and the strict letter of the law does not require such a plan or policy, and you could have a lone genocidaire. The late Professor Antonio Cassese, a founding judge of the International Criminal Tribunal for Yugoslavia, in the second edition of his International Criminal Law, took a middle position and said there's no logical problem with the idea of a lone genocidaire, as certain of the prohibited acts could logically be committed without a greater plan or policy, such as killing members of the group or causing serious bodily or mental harm to members of the group. We don't even need to go as far as the weapons of mass destruction example. One could again imagine a significant population centre for a particular ethnic, national, racial or religious group, and a lone genocidaire attempting to, for example, poison the water supply. However, the point Cassese makes is that certain of the other prohibited acts, for example, preventing births within a group, may by their nature require some sort of collective or even organised action, because they will be difficult to commit without state or organisational backing. Now, the view that ultimately prevailed in the negotiation of the International Criminal Court elements of crimes, and you'll recall from my mentioning it before, this is not a formal part of the statute, it's a separately negotiated document by the state parties, but the court must have reference to it in interpreting its own statute, and indeed must follow its guidance unless that guidance is incompatible with the statute itself. So this question had to be negotiated at the elements of crimes level, and they did conclude that a contextual element was required. The elements of crimes require that the conduct took place in the context of a manifest pattern of similar conduct directed against that group, or was conduct that could in itself affect such destruction. Now that latter element is perhaps consistent with the Cassese view, that you could have a lone genocidaire where you have an act that of itself could affect the required destruction. This approach has been upheld by the International Criminal Court in the al-Bashir arrest warrant case, at least by a pre-trial chamber. However, the same approach has been rejected by the appeals chamber of the International Criminal Tribunal for Yugoslavia in the Krstic case as inconsistent with the Genocide Convention, that this is simply inserting a further requirement. And so we might ask, which of these two cases is the better evidence of customary international law? And given the number of state parties to the International Criminal Court statute and the elements of crimes, we might think that the elements of crimes is a better indication of customary international law, though we would still have to ask questions about whether there really is sufficient involvement by a sufficient number of states for it to be definitive evidence on the issue. We now turn to the question of the mens rea required for genocide. The mens rea for genocide is twofold. First, you have to intend to commit the relevant prohibited act, or the underlying criminal offence that constitutes genocide. But in addition, that offence must have been carried out with the special intent to destroy, in whole or in part, a protected group as such. In addition, under the International Criminal Court approach to the definition of genocide, you might also have to prove that a defendant intended or knew his conduct would form part of a manifest pattern of similar conduct constituting a genocide. Now, we need to note here that intentionally causing or participating in mass killings is not enough. The prohibited act must intend to destroy a protected group in whole or in part as such. Leaders and foot soldiers in a genocidal attack could both be convicted of committing genocide, but only if they have that special required intent. Without it, they might be aiders and abettors of genocide, or they might have committed a crime against humanity of either murder or extermination. So, the mens rea of genocide has a strict intention-based approach as regards this special intent or dolus specialis element. Now, some have questioned whether that strict focus on intention is appropriate. For example, Klaus Kress has put forward the idea that here we have a crime where the mens rea is likely to be that of the leadership. That is, it is the leaders who plan a genocide who are likely to have the special intent to destroy in whole or in part a protected group as such. In Kress's view, there is no necessary requirement that the foot soldiers carrying out a genocide need to share that intention. They might act for any number of reasons. So you could have a situation where there are foot soldiers who carry out the prohibited act but do not have the relevant mens rea, and those who plan a genocide and have the relevant mens rea but do not carry out any of the necessary acts. And he finds this a difficult or paradoxical situation, that you might wind up being able to prosecute the leaders of a genocide for genocide but not the actual foot soldiers. And he therefore advocates what he calls a knowledge-based approach. So you replace this strict intention requirement with a knowledge requirement. Then it would be enough that the subordinate perpetrator acted with knowledge that the campaign furthered by his act would destroy in whole or in part a protected group as such. Now, even if we think this approach has logical merit, it has not been followed by any of the international criminal tribunals, all of which continue to insist on a strict intention-based mens rea standard for genocide. A few further issues arise from the definition going to the question of intent, and they come from three groups of words: to destroy, in whole or in part, and as such. And we'll go through each of those in turn. The first point is that the concept of destruction involved here is limited. It's limited to the physical or biological destruction of the group. And we have the Krstić decision of the International Criminal Tribunal for Yugoslavia trial chamber for that proposition. The essential point here is that destruction does not encompass cultural destruction. At least in law, there is no such thing as a cultural genocide. The next question is the meaning of the words in whole or in part. These were explained in the Bosnian genocide case of 2007 by the ICJ in the following way. First, the intent must be to destroy at least a substantial part of the particular group. That is demanded by the very nature of the crime of genocide, since the object and purpose of the Convention as a whole is to prevent the intentional destruction of groups. The part targeted must be significant enough to have an impact on the group as a whole. So the intent has to be to destroy a substantial part of the group. Obviously, one does not have to succeed in that aim to have committed genocide. It simply has to have been intended. The ICJ went on to state, second, the court observes that it is widely accepted that genocide may be found to have been committed where the intent is to destroy the group within a geographically limited area. In the words of the International Law Commission, it is not necessary to intend to achieve the complete annihilation of a group from every corner of the globe. Therefore, it might be enough in the course of a civil war to intend to wipe out a protected group within a region. However, the ICJ notes that defining the relevant group as one present within too limited a geographic area would risk distorting the meaning of genocide. Finally, we have the meaning of the words as such. And really what these words go to is they reinforce the special intent requirement, that you are attempting to destroy an individual as a member of this group for no reason other than that they are a member of the group. So if, for example, you attempted to destroy a population in a particular area that held a political view, and 90% of those who were killed belonged to a particular national, ethnic, racial or religious group, that would not establish that you had committed genocide. So the authorities we have along this line are, for example, the commentator Antonio Cassese, who noted that genocide is a crime where the victim is not targeted on account of his or her individual qualities or characteristics, but only because he or she is a member of a group. And reinforcing the point that the distinction here is one between intention and motive, Cryer and his co-authors in their Introduction to International Criminal Law state, the discriminatory nature of genocide seems to require a motive. The victims are singled out not because of their individual identity, but because of their membership of a national, ethnic, racial or religious group. And that is the intention behind the use of the words as such. Thank you for listening. This concludes our discussion of the law of genocide, and in the fourth and final one of these recordings, we will consider principles of liability. That is, the legal concepts that allow us to relate offenders to international crimes, and particularly to describe the responsibility of leaders for international crimes.